Hello and welcome to Beyond Final Written Decisions, a primer on Federal Circuit PTAB appeals, part of Virtual Patent Gateway's PTAB Practitioner series, hosted by Virtual Patent Gateway founder Ashley Chung. Virtual Patent Gateway, VPG, was founded in January 2020, right before the pandemic, and Ashley has a passion for supporting PTAB practitioners and is committed to developing a growth mindset within VPG. Today, we're happy to have Angela Oliver to share her experience and knowledge on Federal Circuit PTAB appeals. Angela is an appellate and intellectual property attorney who focuses her practice on appeals before the U.S. Court of Appeals for the Federal Circuit, federal district court litigation, and post-grant proceedings before the U.S. Patent and Trademark Office. Her expertise includes a wide array of technologies, including medical devices, surgical tools, computer hardware and software, wireless communications, high-efficiency video coding, and business methods. This webinar will be recorded for future use. We have applied for Virginia CLE for 1 hour pending approval. Ashley will notify you once these are approved. You're welcome to stay on camera for today's session, and there will be a short Q&A at the end of the presentation. And with that, I'll hand it over to Angela.
I'm very glad to be here today. Welcome to Virtual Patent Gateway's Patent Practitioner series. If you've had a chance to watch some of the other presentations in this series, they're very good, very informative. Hopefully this one will be as well. Again, my name is Angela Oliver, and I primarily practice before the Federal Circuit in a variety of patent matters. I've had the privilege of handling a good number of IPR appeals, as well as district court and appeals from patent prosecution as well. I was privileged to clerk at the Federal Circuit for about a year and a half before starting in private practice, which gave me the opportunity to, watch many IPR appeals come before the court. I had a chance to study the briefing, see the oral advocacy of the various practitioners that came before the court. And I really tried to take note of effective strategies and things that were not so effective while I was there at the court. So hopefully I'll be able to convey some of that information today, and it will be helpful. As far as the topics we'll cover today, I have quite a few in my slides, and we'll spend more time on some than others. But essentially every stage of the appeal process. So starting with, rehearing before the PTAB, going through the fund notice of appeal process, preparing the appellate record, the overall timeline you should expect in one of your appeals, confidentiality issues, of course, briefing and oral argument. We'll discuss some various briefing strategies that are effective. We'll talk about requests for rehearing at the Federal Circuit level once you have an opinion from the court. And then, briefly touch on standards of review and other strategies that can help you on appeal. So with that in mind, we'll definitely talk about, strategies, about things you might consider here and there. We'll also talk a lot about just the nuts and bolts of how these appeals work. If you have not practiced before the Federal Circuit before, there are just a lot of, little things here and there in the rules that you might miss if someone hasn't flagged them for you. If you haven't printed out the Federal Circuit's most recent set of rules, it is a very thick item to keep on your desk. It's helpful. It has the Federal Circuit rules alongside the federal rules of appellate procedure, all of which are very important to know if you're practicing before the court. So without further ado, we'll get into all these topics, but I would be remiss if I did not talk about just briefly the issue of the day, which of course is the Supreme Court's decision in Arthrex. So this decision came out last Monday, as I'm sure everyone is quite aware. I hope you've had a chance to read the opinion. I think it's very important to read it very carefully and thoughtfully, because there's really a lot jam-packed in there to think about. As far as timing of the court issuing its opinion, this is very late in the term for a patent case, but I guess we saw Minerva come out late this year too. But the other interesting thing about the timing is that Arthrex came out Monday, and the next day a decision in Collins came out. And I think it's important for patent practitioners to read Collins as well. It is not a patent case, but it is a case that involved removal protections. and the remedy that was available for the violation in that case. And so I think after reading Arthrex and then after reading Collins, you can see some consistency in the opinion. And I don't think it's a coincidence that these came out around a similar time, because all of these concepts of separation of powers and what removal restrictions are permissible, what review is required, et cetera, these are all very interrelated concepts. The court has taken a lot of these cases in the past couple terms, and I think we can really kind of see the direction where the court is headed when you read these cases in conjunction with one another. So if you have time, I would read Collins as well, because I think it's informative. So back to Arthrex itself. Of course, the issue in the case we're all familiar with, because we've been dealing with it since Halloween of 2019. And the way that the court framed the issue in its opinion was whether the nature of the APJ's responsibilities is consistent with their method of appointment. Now, I flagged this in here and I used the court's language because there was a bit of an issue framing dispute between the justices in Arthrex. And I think you can see that about page 19, perhaps, of the opinion. And you can see that there's some question of, was there an improper appointment, or was it really these were inferior officers that were acting beyond their permissible scope in doing duties that they were really not permitted to do. And so, ultimately the court doesn't directly address that. They hold that the unreviewable authority that APJs wield during IPRs is incompatible with their appointment by the secretary to an inferior office. And so with respect to this issue framing dispute, Justice Roberts explains, it really doesn't matter because the constitutional violation is the same. And here's the key theme in all of this: that only an officer properly appointed to a principal office may issue a final decision binding on the executive branch. And essentially the policy here is that this allows the president to remain responsible for the exercise of executive power, and through the director, in this case, we'll discuss more, the exercise of that executive power remains accountable to the people. So this is really the direction that the court, it seems to be headed with these areas of case law in the appointments clause, removal, et cetera, context. So the practical reality of Arthrex, what it means for us, the fix that the Supreme Court provided, of course, is a bit different than what we had seen from the Federal Circuit in the Federal Circuit's Arthrex opinion. So here, the court held that decisions by APJs must be subject to review by the director. So essentially, the statute that we're familiar with, 35 USC 6C, which precludes review by the director, of course, cannot be enforced because it prevents that review, and that review is necessary to the constitutional structure of this regime. So the particular remedy, as far as what Arthrex, the party, received in that case, is a limited remand to the acting director for him to decide whether to rehear the petition. So that's kind of practically where we are. And I think there are some important qualifications that the court includes in its opinion that will shape what we see going forward and how this affects, the high number of cases where Arthrex was an issue. So first of all, the court explained very clearly that the director does not need to review every decision of the board. What matters is that the director has the discretion to review those decisions. So I think that gives us some clarity with respect to, is this a right that we always get to have the director take a second look, or is this something that's more discretionary? This is very similar to how many agencies operate, where there is an initial decision maker, and then that decision maker, the decision becomes final after a period of discretionary review by a higher officer. So this is not atypical. Another clarification the court explained is that patent owners are not entitled to a hearing before a new panel of judges. And the court distinguished Lucia briefly on this point. I think reading these cases in tandem, reading this, reading Collins, reading Lucia, you can kind of see where the distinctions are becoming more clear with respect to what the remedy should be in these circumstances. But the important part is what we thought was going to be the remedy, all the cases that were vacated and remanded to the board for a new hearing with a new panel, that is not what patent owners are entitled to, according to the Supreme Court. And the last qualification, I think, only applies to a few cases where there were Arthrex remands, but the court explained that its holding really only applies to IPRs, or at least that's all the court was deciding. It does not necessarily extend to other types of adjudications that the board conducts. So the example that the court gave is, examination proceedings. The court noted that the director retains ultimate authority to issue patents or not. And so there's perhaps a different analysis regarding the director's review powers there. So those are some ways that the decision, I think the court kind of helped us understand the scope of its decision and the import as far as practical effect going forward. Now, with that said, much remains to be seen. As I'm sure you're aware, the Federal Circuit issued a sua sponte blanket order 2 days after the Supreme Court's opinion in most cases where Arthrex is in play. I have seen a couple cases here and there where this order was seemingly did not cover those cases or the issue has yet to come up in those cases. So this may not be the only sets of briefing that we'll see regarding Arthrex, but this will certainly be the main set. Essentially, the court requests supplemental briefing regarding how cases should proceed after the court's opinion. The briefing will start with the patent owner. They'll have 14 days to give their opinion, and then the USPTO and the petitioner side will have 14 days as well. So this is a time that a lot of practitioners are very focused on Arthrex, very focused on how this impacts each and every one of their cases. I have a good number of cases where Arthrex is in play. And so we're looking at the facts of each case and trying to determine the best arguments to raise. So finally, the last thing the order does is in all of those cases that are affected, it stays all deadlines and proceedings until further notice. So we're kind of on hold until some of this stuff gets sorted out. Now, with respect to what the PTO has done so far, I'm sure you've seen that yesterday, the PTO issued some interim guidance with respect to how it's going to implement this director review process, at least for now. And so essentially what the PTO has said is that director review can be initiated sua sponte by the director or requested by a party to a PTAB proceeding. And so there's a couple options how that could come up. But the important thing for practitioners really is to mind the deadline, because right now the PTO has explained that this will be tied to the typical request for rehearing deadline, which is pretty quick, 30 days after entry of the final written decision. So if you are in your rehearing period right now, you should be considering this and seeing whether this is something that you'd like to do. The PTO has provided more guidance with respect to how precisely this will work out. So, for example, a party can request director review, or in the alternative, also request panel rehearing. And then if a party requests only director rehearing and that's not granted, then you cannot go back and request panel rehearing. So, style your motion correctly here. And then if panel rehearing is granted, parties will be permitted to request director review of the panel rehearing decision following this procedure. So make sure you're following this guidance closely, especially if you have cases where final written decisions issued recently or are coming up soon. This is kind of a whole new world. I believe, if I recall, I've seen one petition so far. I have not had a chance to study it yet. But this is the new wave as far as what's happening at the end of the game before the board. So I've included the main website here for where the PTO is posting this information. If you click on that, there is another link in there to a Q&A page that has a lot of helpful information. I suspect that will be updated as this goes forward. They've explained that there's going to be opportunities for public comment and feedback on how this process is going. So stay tuned. It's going to be an exciting time figuring out how to implement this going forward. So that leads us to our first topic with respect to non-Arthrex issues, rehearing requests at the PTAB. So this is just the basic regulation I've included here. The main point of highlighting this is to emphasize how critical it is that we are very particular in our rehearing request. If you choose to file a rehearing request, we have to identify all matters that we believe were misapprehended or overlooked. and the place where each matter was previously addressed. So if your argument on rehearing is the board forgot to consider my argument, argument X, you should include that in your rehearing request, but make sure you say, and I raised argument X on page 5 of my IPR petition, or page 5 of the reply, or the patent owner response, etc. Make sure it's very clear to the board where exactly the thing they allegedly overlooked was presented to them. So as far as strategy with respect to rehearing requests, it's always a strategy call whether to file one of these. I would say there's a couple instances where I think it's worth considering more than other cases. So the first of those is obviously denials of institution. So if you're a petitioner whose institution decision has been did not go favorably for you, it's pretty much the end of the game for you now that we have Thrive and this 314D bar. That's not reviewable. So unless you can get that flipped via rehearing, you're a bit stuck. And it has become, I've seen quite a few instances now where the board has actually flipped its institution decision based on a rehearing request. I've included just one recent example here where the board had originally denied institution, and then earlier this month, the board changed its mind and granted institution based on a rehearing request. So it is possible. I've seen that happen a few times. I believe our firm has had at least one instance where we've been successful doing this. So that's one option to consider, a good time to file rehearing. Another time that you should consider rehearing fairly strongly is if you have an APJ that dissents in your favor. So if you've lost the final written decision, but you convinced one judge, then you should really consider rehearing in that context. So I've included another recent example here of where this worked. So in this Shopify case, the final written decision was originally a split decision with respect to certain claims were held unpatentable, others were not. And the dissenting judge indicated that he agreed he would have held differently with respect to some of those claims. And so on rehearing, they were able to change that outcome and actually have all of the claims invalidated. So if you see a dissent that's in your favor, it's a good chance to tailor your rehearing request and just align with that dissent as much as possible. And basically view your rehearing request as an opportunity to just win over one more judge. You need to give as much information as you can to help the dissenting judge who already agrees with you, help them be able to convince their colleagues that their colleagues should change their mind and join the dissenting opinion or the dissent's view. So this is true with respect to the Federal Circuit as well. But essentially you have someone, somewhat on your team, and you can just do the best job you can to give them what they need to flip the decision. So even if some of the, explanations in the dissent or maybe not how you would have worded it precisely or something like that, work with what you have and consider that. So those are two instances where, I think rehearing may be a more viable option. As we all know, it's still very rare that decisions are flipped on rehearing, so keep that in mind. I would say overall, it is not advantageous to file rehearing if all you're going to do is rehash the same arguments. If you have 3 judges that have held against you on your arguments on the merits, and you are just going to raise those same arguments again and say that they just were wrong, I don't think that's a productive use of time or money. And so I would not typically, every case is fact dependent, of course, but I would not typically advise a rehearing request if that's the strategy going forward. So 2 words of caution, I guess, with respect to strategy on rehearing requests. One, there's always the risk that you could lose your rehearing request, and in the process, the board can actually bolster its own opinion and make its own opinion and reasoning stronger, such that by the time you get to the Federal Circuit, you're actually in more of an uphill battle than you were in the first place. So that's something to consider. Another point to consider is this case that I flagged on the slide here called Polycom versus Fullview. Now, this is a non-precedential Federal Circuit case, so it is not binding on any Federal Circuit panel. but it does represent the views of 3 judges in a particular case. And so that is something to consider. It is in a slightly different context. It's in the re-exam context. And the rehearing regulation for re-exam has some different wording than the IPR rehearing regulation. But I think it is worth reading if you are going to consider a rehearing request, because what happened in this case is the court actually held that the party requesting rehearing had waived their opportunity to argue anticipation, the merits of an anticipation analysis, by not including anticipation issues in their rehearing request. And so essentially, you can see some of the court's reasoning here on the slide, but the court said that, well, while Polycom could have directly appealed the board's decision to the court, it made the strategic choice not to. It decided to file rehearing instead. And because it made that choice, it was required to include all of the points at issue in its rehearing request. So this decision has always given me a bit of pause, just because it suggests that if you're going to file rehearing, then you need to raise every possible issue you want to raise on appeal in your rehearing request, which of course may not be very efficient or make sense at all in a particular case. Now, again, this is a different regulation. It's in the inter partes re-exam context, and this is a non-precedential decision. So it could mean nothing. This could never come up again, but it is a decision that's floating out there. I've seen it come up in various contexts. And so it's just one more piece of the analysis when you're considering whether to file a rehearing petition. So moving on away from rehearing before the PTAB, let's talk about the logistics of a Federal Circuit appeal once you get there. So this is just a nice overview chart that the Federal Circuit provides on their website. We will not go through all of this, but I have the link here if you'd like to study it more closely. But it basically shows you the overall stages of these cases. And we're going to talk through those piece by piece today. Some of it will feel very just run of the mill, going through some rules and requirements, but if you have not practiced often before the Federal Circuit, again, I think this will be helpful to you just because there are some logistical issues to consider here. So from the beginning, we have the notice of appeal stage. Of course, when you're looking at preparing your notice of appeal, there are a lot of sources that you need to consider. So you need to look at the statutes, the regulations, the federal rules of appellate procedure, the Federal Circuit's local rules as well. And so all of these have various requirements about how to make sure this is done correctly. I will say, in my experience, notice of appeal filing days are some of the most hectic days for me. I'm just trying to make sure everything is done perfectly to a T, to make sure all the regulations and rules are handled correctly. This is just the statute providing for appeals, but I will use the slide to say a few very practical tips regarding filing your notice of appeal. The PTO regulations are very particular with respect to the delivery requirements to the USPTO. You should study these carefully. My typical practice is to hand deliver, not via courier service, this to the PTO so that I can get the file stamp showing that it was received by the PTO on the day I think it was received by the PTO. And I am not done with my day until I have that file stamp in hand. That has worked well for us. There are other ways to make sure that the PTO receives the delivery, but they're very particular requirements. So you should study those carefully. There are also the other requirements regarding electronic filing at the PTAB, at the Federal Circuit, et cetera, and there's service requirements as well. So practically, the thing to do is make yourself a very thorough checklist of everything that needs to happen the day that you are filing a notice of appeal, because there's just a lot that can be missed if you aren't studying these rules carefully. So let's talk a little bit more about some of these rules. The primary regulations from the PTO on this with respect to IPRs are found in 90.1 through 90.3 of Title 37, excuse me. And the two things I want to highlight here are the timing of the notice of appeal and what to include in a notice of appeal. So timing is absolutely critical. Inside patent law and outside of patent law, timing of a notice of appeal is typically jurisdictional, which means if you miss the deadline, there is nothing that the Federal Circuit or the Court of Appeals can do to help you. It is very important to make sure you hit this deadline. I often recommend filing, a few days early, just in case something goes wrong, you have time to fix it. But if you wait until the last day and something does go wrong, you could really be in a bind. So make sure you understand the deadlines clearly. In 90.3, the deadline is 63 days after the date of a final written decision. That changes, of course, if you have the rehearing, in which case it will be 63 days after action on the rehearing request. So make sure you're familiar with those. With respect to the contents of a notice of appeal, they're fairly short and straightforward. I typically have maybe one page double-spaced, a page and a half of contents in there, and that's mostly citations to the various rules that apply. There's not a lot of analysis, but one thing that is unique to the IPR context is found in Rule 90.2, Section A3, and the regs require that the party gives sufficient information in the notice of appeal to allow the director to determine whether to exercise the right to intervene in the appeal. So if you know at the outset you have an issue that the director may want to intervene, better safe than sorry to just mention that in the notice of appeal. Of course, we've seen over and over with Arthrex that the director has intervened later in the case, but that requirement is there in the regulation. So be aware of it and consider what you might need to put there. Typically, I'll include the claims of the patent at issue in the decision that are being appealed. I'll make reference, of course, to the final written decision of the board, but otherwise these are fairly straightforward substantively. Now, one thing on the scope of the what to include in the notice, I want to mention Federal Rule of Appellate Procedure 3. This governs the contents of a notice of appeal just generally across all courts of appeals in the country, not just the Federal Circuit. And there is a proposed amendment that we expect to go through this year that would take effect on December 1st of this year, unless Congress takes action otherwise. But essentially, to sum things up, this is going to make notice of appeals a bit easier than even before. And essentially, there was currently a dispute of how many orders you need to list in your notice of appeal. Do you just put the final judgment, or do you put every interlocutory order that you might want to deal with on appeal? Do you have to list all of them? And so that's been a point of confusion for appellate practitioners for many years. And so this is being clarified now. You can see in the subsection 4 on the right that the notice of appeal encompasses all orders that merge into the designated judgment or appealable order. It is not necessary to designate those orders in the notice of appeal. So this is intended to kind of clarify that issue and say, look, we all know these things merge into the final judgment. And so there's no reason to list everything out. So again, this is not currently in effect, but we expect it to take effect this December. Practically, I don't think it will change too much with respect to IPR appeals because there are so few orders anyway, unlike a district court appeal. But it is important to note that this is about to change, hopefully in a way that's helpful. Okay, so moving past the notice of appeal, we're just going to get into a couple of logistical items and go through these for people who may not be familiar. So once the notice of appeal is filed, there's typically maybe a 3 to 5, sometimes longer day delay before it's docketed. So, even if you're a party in the case, you will not see it docketed for a while. Now, once it's docketed, that starts kicking off some deadlines. 14 days after docketing, you have your initial filings due. The entry of appearance for the attorneys, the certificate of interest for the client, and the docketing statement. And so these are very straightforward. All of these forms can be found on the Federal Circuit's website. I've listed the form numbers here just for reference. A couple things to note. On the entry of appearance, this is much easier now than it used to be. All of the attorneys are on one form. It's important to make sure the address you list on this matches the address the Federal Circuit thinks that you have. Otherwise, your filing will get rejected and you'll get perhaps a phone call about your address. So make sure your address is up to date. With respect to the certificate of interest, again, this is a fairly straightforward form, but I would recommend just going ahead and making it into a Word version for yourself. because you will use this form over and over throughout even just one appeal. You have to file it with your briefs, you have to file it with certain motions. So it will come up, you will sometimes have to update it with a new related case or something like that. And so it's easy to just have it in Word form so you can put it where you need to quickly. With respect to the docketing statement, this is something that is designed particularly by the Federal Circuit, just gathering information about the case that helps the clerk's office kind of sort the case appropriately. I want to mention the related cases section. This is one way that the clerk's office helps understand what cases should be designated as companion cases or consolidated cases. And so, think hard about, if you have related cases, you need to mention them here. And the practical effect is, if you're not familiar with the companion case and consolidation designations, companion cases will be heard on the same day, have oral argument on the same day, typically by the same panel, unless there's some very unusual circumstance. The filings remain separate in companion cases, but they are heard by the court on the same day. Consolidated cases are a little different because they're actually, the filings occur in one case and there's some overlap in briefing that can occur there. So that all starts with the docketing statement, because that's where you're flagging these kind of related cases. So after the initial filings, you have a little bit of a break, but pretty soon you will start developing the record for appeal. And there's plenty of rules about this in the Federal Circuit's process, in their local rules. IPRs are actually relatively easy in this respect. In my experience, experienced practitioners, I think, have found that the easiest thing to do is for the parties to agree to designate the entire IPR record. And once you agree on that, at the end of the day, IPR records are fairly small compared to district court. And so it's easy to do. And once you've done that, then the appellant will typically put together a working appendix, put all the documents together in the correct order under the rules, which we'll get back to. The correct order, they'll go ahead and number them with the proper appendix format numbering, and number 1 through 2000 or however many pages it is. And then the parties will each use that working appendix to prepare their briefing. And so you can use that, cite the pages, what the appendix site will eventually be because you have already done this. And then jumping on our slide real quick to the joint appendix, at the end of the day, after the briefing is finished, then the appellant will prepare the joint appendix by removing from the working appendix the pages that are not cited by the parties. So that's how we make the final joint appendix. So it's perfectly normal to have a joint appendix that will have, appendix page 500, and the next page will be appendix page 783, because nothing in between there was cited. That's completely normal. And it just reflects this is kind of the easiest process that IPR practitioners have learned to use, the Federal Circuit. So that's kind of how that process works. A little more on the joint appendix. Again, it's prepared by the appellant. And there are often errors in how this is done, just because it's complicated and there are a lot of rules. But I would advise looking to the Federal Circuit's website. They have compiled kind of a cheat sheet on how to prepare the appendix. It has font sizes, it has the proper order of the contents. That's probably the most important thing. You need to make sure you get right at the outset, because if you number your pages wrong because you had the order wrong, then you're going to be in a heap of trouble when you realize all the citations in your briefing were wrong. So make sure you get the order of contents correct. And again, it's in the rules, and the Federal Circuit has some cheat sheets for this. So make sure to spend some time getting that done correctly. The last practical thing here is just, I'll mention the addendum. The addendum is what is attached to the opening appellant brief, so the blue brief. And it's at the end and back of the brief. And essentially it includes the final written decision from the board and the patent, the challenged patent. And those should be numbered corresponding with how they're going to be numbered in the joint appendix. But essentially it just makes it easier for the court to have the main decision from the board and the main patent there for ease of reference. A recent development is the court has also asked parties to put the language of a patent claim at issue on the inside cover of each principal brief, so the blue brief and the red brief. So I will typically include, if there's the main independent claim at issue, if that's representative of everything, I will typically just include that. But I will always want to make sure that if any representative claim I think is necessary should be there. So I'll sometimes put claim 1 and then maybe dependent claim 6 if that's at issue or something like that. But if claim 1 and claim 12 are basically the same thing, I sometimes will just put 1 because there's no need to add something that is not particularly helpful. Okay, so just moving through this, this is a shorter version of kind of the overall timeline of how things go. So we'll just jump through this quickly so that we can get into some more topics. But we've talked about initial filings, we've talked about preparing the record. What really kicks off these substantive deadlines in an IPR appeal is when the agency files or serves the certified list. And that distinction is important. So the USPTO will serve on the parties a list of all the record in the proceedings. I will say they do not typically include the exhibits. So when you receive a certified list, if you don't see any exhibits, for whatever reason, that's just how they typically do this. So don't be surprised. But once that is served, the PTO will typically file it on the docket 2, either the same day or a couple days later. But your deadlines run off the service of the certified list. So don't get confused there. Don't think that it runs off the filing of that list. That's really just a matter of convenience. You should focus on the service date. So the opening brief will be due 60 days after that. Then the appellee brief, 40 days after that. After those first 2 principal briefs are filed, there is a requirement for the parties to discuss settlement. This is often overlooked in my experience. And that's because this is a fairly new rule for the IPR practitioners. This has been around for the district court cases for many years, but it was really, I believe, a 2019 rule change at the Federal Circuit that extended this to IPR proceedings. So you can look at the rule and you can kind of see where that comes from. But essentially, you have an obligation to speak to your opposing counsel about whether there is a chance of settling the case. As you know, typically that with a patent being invalidated, that sometimes is not an option in an IPR, but this requirement still exists. So that's after the principal briefs. And then, of course, the reply brief comes in shortly after that. And then the parties coordinate filing the joint appendix and their Rule 33 certification statement, which says to the court, we did indeed talk about settlement and we've complied with the rule to do so. And here's our joint certification saying we've done so. So again, it's important not to forget this settlement discussion piece because you do have to file the certification down the road. There's also a confidentiality certification that's due around that time. It only applies in cases where you have confidentiality issues from the court below. So I've not listed it here, but that also is a rule to make sure you're aware of. People often ask me about paper copies, whether you're supposed to file them the day you file your brief or some other time. It's different between circuit courts, but the Federal Circuit will tell you when they want the paper copies. So sometimes a day after your joint appendix is filed, sometimes longer, the court will issue a request for paper copies to be submitted. And you'll have a couple days to get those to the court. So, be ready to do it quickly once you receive that order. Okay, so another practical topic that, again, is another thing that has changed fairly recently at the Federal Circuit is dealing with confidentiality issues in your briefing and joint appendix. So these are very long rules the Federal Circuit has included, and they're worth reading in full because there's a lot of requirements here. This is another chance where it's a good idea to make a long checklist for what you need to do on filing day for confidential briefs because this can get messy. But essentially the general rule is you are allowed to mark in each of your briefs up to 15 unique words, including numbers, as confidential. And if you want to do more than 15, you have to seek permission from the court and explain why, etc. So that's not very many words. So you have to, be judicious in what you choose to keep confidential. And then once you've done this, when you go through the filing process, there's a lot of particular requirements. You have to file 2 versions of your brief. So the confidential version and a non-confidential version. And I've listed some of the requirements here that are detailed in the rules, but there's very particular formatting that they want for this. So in the confidential brief, you have to mark the confidential material either in brackets or by highlighting. I typically found when I was at the court that the highlighting was more helpful because otherwise or actually I've seen some parties do both just to be safe, but the highlighting just sticks out a bit more than a bracket, in my view. And then the non-confidential version of your brief, not only do you have to mark it non-confidential, you have to redact the information you're expecting to redact, but then the rules also require each page with redacted material to bear a legend so stating. And I'm personally not exactly sure what that means, but what has been successful and what I have done is put a large red statement at the top of each page with redactions that says this page contains confidential information or redacted information. And that has been sufficient to comply with this so far. So that's one option. There may be others. You also have to include a general descriptor on top of the redacted material. So if you redacted the total profits you made in a year, it's like $1 million or something, you have to redact that. And then on top of the redaction, put, in brackets, something that says like profits or money amount or something, so that the public generally knows what you've redacted if they couldn't figure it out from context, but at least it's there. And you also have to include a paragraph in your table of contents explaining all the nature of the deleted material and the page numbers that it's found on. Plus certificates of confidential material. So there's really a lot, there's a lot going on here when you have confidential filings. It takes an inordinate amount of time to put this together and make sure it's done correctly. And of course, it's very important to your clients because this is their confidential information, and just preserving it takes a lot of time at the Federal Circuit. One more thing before I turn to the next topic on this, make sure you're aware of the service requirements for the confidential versions. So when you file the confidential version on CME-CF, that will not count as service to the opposing side because they will not receive the document because it's marked confidential and CME-CF doesn't know, who's allowed to see it. So there are different service requirements than usual for serving the confidential documents. Okay, so let's switch gears and talk about oral argument. And then towards the end, we'll get a bit more into briefing strategy. I know we're running short on time. Let me just run a couple of things here about oral argument. The default at the Federal Circuit is that parties receive oral argument. The court's very generous with their time. It's one thing I really love about practicing before the Federal Circuit is if parties have counsel, they are typically entitled to an oral argument. Now, of course, we've seen that change a bit during COVID, but I think things will be returning to normal, hopefully soon. As you know, we'll be going back to in-person arguments beginning this September. So that's exciting. You don't receive your panel assignment until the day of argument, the morning of. During COVID, it's been about 1 hour before the arguments begin that you'll see the panel assignment. You'll have 15 minutes per side. And unfortunately, at the Federal Circuit, you cannot split time with other attorneys. So don't expect to have one person argue claim construction and the second person argue the merits. That's really not favored at the Federal Circuit. The court hears argument during court week. This is one thing that's also unique about the Federal Circuit that is a lot of fun. If you're a practitioner in DC or you're visiting, if you can make it during court week, you can see tons of arguments, tons of practitioners presenting their case during the first full week of each month. So it's a very exciting week at the court because there's so many arguments going on. Logistically, just so you're aware, when you receive these orders from the court will issue 2 orders related to oral argument. One is a notice to advise of scheduling conflicts. You have to respond to that and basically say, during the months the court has suggested for argument, I have conflicts on these days, and here's why. The court is very strict about these conflicts. You can only submit a maximum of 10 days, and you have to submit a statement explaining and showing good cause for why you have conflict on those days. So that's, don't expect to just schedule these things on your terms. The other order you'll receive is very closer to oral argument. You'll receive a notice of oral argument that will have the date of argument. They typically schedule these about 6 weeks before the argument is heard. So, for the August court week, you would typically hear maybe like mid-June-ish or something like that. And you will have to file a response to that notice that basically says who's arguing, how much time to reserve for rebuttal, etc. So in our last few minutes together, let's talk about a couple briefing strategies. Of course, let's do rehearing requests first, and then we'll touch on briefing strategies. Okay, so rehearing at the Federal Circuit is different than other circuit court of appeals. So in other circuits, it is extremely frowned upon to file a petition for rehearing. In some circuits, it is almost sanctionable unless you have a really good reason to file one. That's not really the culture at the Federal Circuit. There are many, many requests for rehearing filed, but as we know, there are very few granted. Sometimes the panel will grant rehearing and fix something here or there. Sometimes the court will take the case en banc, but again, that's very rare. But it is more flexible as far as like whether you have the ability practically to file one. So here's just some practical points about it. I won't go through all of this other than to say your likelihood of rehearing is largely dependent on whether the case is precedential, because then it really is the law and it will govern. So that's an important factor to consider as you decide whether to file rehearing. And also, again, if there's a dissent that is in your favor, that's a good opportunity to try to seize on. But otherwise, unless there's a really important question of law, if it's just a factual dispute between the parties, you're unlikely to succeed on rehearing. Okay, last few minutes, we'll wrap up with some briefing strategy points before we open up for questions. Hopefully you have some questions. If not, no worries. So let's talk about standards of review. This, of course, is the lens through which the Federal Circuit views your case. If it's a factual issue, if your dispute on appeal is the board looked at the evidence and they got it wrong, the evidence should have gone the other way. That's really a factual dispute, and the court is required to apply the substantial evidence standard of review, which basically just asks, is there some evidence, in the record that supports the board's conclusion such that a reasonable mind would accept that conclusion? Even if the court would have reached a different conclusion, the court should affirm if the evidence, if a reasonable mind could reach the board's conclusion on that evidence. So it is difficult to get decisions flipped when that is your argument. It is possible, and it does happen, absolutely. But you are fighting an uphill battle based on the standard of review. Now, of course, if you have an issue that is de novo review, then the court has much more flexibility. So issues that are de novo review are questions of law, statutory interpretation issues. I will say generally claim construction is mostly de novo review. Of course, we have the TEVA standard, which has subsidiary factual findings that are based on extrinsic evidence. Those are reviewed for substantial evidence. But the overall claim construction issue is de novo. So often you will see parties try to turn disputes into claim construction disputes for the purpose of changing the standard of review. Now, if it's been a true claim construction dispute, the whole case, then that's just how it is. But oftentimes parties will try to kind of reframe things to make it that kind of review. And it's typically transparent when that's what's happening. And so often the court will just say, this is really a substantial evidence issue, and we apply that standard of review. So with respect to briefing strategy, I just have a few main points to say here based on my experience writing many of these briefs, appealing IPRs, and reading many briefs as well. The biggest thing to consider is clarity. Clarity is absolutely the key. Whether you are the appellant or the appellee, your brief needs to be absolutely clear. You should spend a lot of time just making sure that your brief is clear. And that often means you shouldn't be running up against the word limits. We have 14,000 words in the principal briefs on appeal, and if you're a Brian Garner fan, he often suggests you should use half of your word count, 7,000 words. I've only done that once or twice. I'm typically more in the maybe 10,000 range, but you should not drone on and on. You should not repeat arguments that you've already said. The court has so many cases it hears every week, and they're reading all those briefs at the same time. And you don't want the court to be scratching their head saying, I don't really even understand what this party's position is. They should understand your position. And if they reject it on the merits, that's fine, but at least they've understood it. So the way I write when I go through this to try to make it the most clear is I spend the vast majority of my time working on cases just thinking and reading the record and reading it again and thinking and taking notes and researching the case law over and over, kind of in a cyclical pattern of going back and forth wherever I need to in the record or in the case law. And only after that do I start trying to put it together in a structure where I think the arguments are the most persuasive. And then only after that do I bother to start writing. I found that if I start writing at the very outset, then the brief becomes less and less clear. And if you spend more time thinking and less time writing, I've found that the brief becomes more clear, more effective for the court, more persuasive, because you've really narrowed down the issue to what absolutely matters, to what the court needs to understand. And I think that that's really the key to being a strong appellate lawyer, having strong appellate briefs, is telling the court precisely what it needs to know in the clearest and most concise fashion that you can, and kind of removing all other distractions from the court. If there's a side issue, you can say, that's a side issue, the court doesn't need to address it, or that's a side issue, but even if the court wants to address it, it doesn't matter, things like that. So anyway, and then the last point I'll mention on briefing strategy, and then we'll open this up, is just also to be creative. The Federal Circuit does not handle only patent law. They handle a variety of cases. And in fact, if you look at the statistics from the last couple of years, they have actually handled either the same number or more administrative law cases than the DC Circuit. And so they are very involved in agency proceedings, the veterans cases, they have MSPB cases, they have a large variety of cases they hear. So look to other case law, look to analogies that you can make. Look at the veterans context, see what they're doing there. Look at other contexts of patent law, see what kind of arguments you can compare your arguments to. Just be willing to think a little bit outside the box, and maybe help the court view things in a different perspective, if that is effective for your appeal. Okay, so last thing here is just a couple things to watch, what's coming up at the Federal Circuit. Of course, we just transitioned to a new chief judge. The wonderful judge that I clerked for, Judge Prost, is no longer chief. And the wonderful judge who has been there for many years, Judge Moore, is now chief. So that's a new and exciting thing that's happening. We also have an expected confirmation of a new Federal Circuit judge, Tiffany Cunningham. She's going to be fantastic, I'm sure. And so that's coming up as well. It'll be interesting to see, how she affects the court's jurisprudence. And then, as I mentioned earlier, we have in-person arguments coming up in September. And as I mentioned just briefly with respect to the DC Circuit, the court's increasing role in administrative law. If you haven't, started studying admin law yet as a patent practitioner, if you're in the IPR space often, I think it's very helpful to do so. You need to be familiar with concepts like Chenery and Chevron and Skidmore and hour deference. All of those concepts, you should have a basic understanding of them, because they can come up at any moment in the middle of an argument, in the middle of your briefing, because at the end of the day, the PTO is an agency and operates in this world of admin law. So that's about all I have. So if anyone has any questions, I provided some more additional resources for you here in the slides, just to gather more information about the court and procedures, etc. But that's really it. So thank you for letting me spend this time with you today. And it's really been a pleasure, and I hope it's been helpful.
Thank you so much, Angela, for taking the time and sharing both your expertise. And this was a masterful presentation. And I also want to thank everyone for attending this. And I'm just going to open this up to Q&A. You're welcome to unmute yourself or ask to be unmuted, or you could also chat the questions if you want to.
Jonathan did have a question in the chat. For IPR appeals, when is it appropriate to ask for a reversal as opposed to a remand?
Yeah, okay, so that's a very good question. And this is a strategy call in every case. There are often times where if you're seeking reversal, it feels like a stretch. Particularly if it's a factual issue and you say, well, the this alternative ground should have been considered. That would have carried the day for us. So the court should reverse and based on this alternative ground, hold in our favor. Well, there's likely some factual issues there that need to be decided by the board, who typically decides them in the first instance. And so basically what you're saying when you're asking for reversal is no reasonable fact finder could conclude otherwise, therefore the court, based on the evidence, should go ahead and reverse and not allow fact finding. And so in some cases it's appropriate. In some cases it's best to briefly ask for it and then move on quickly, because at least you've asked for it, in the sense that if the court wants to go there, you've given them an opportunity because you've asked for it. But I often saw at the court parties make arguments for reversal, and then when they were pushed on it during argument, immediately back down and say, well, at the very least, a remand is appropriate. And so I think if you choose to ask for reversal in a case where there's arguably factual issues, you should be willing to know how much you're asking of the court, and if it's appropriate, be willing to back down on that quickly and be happy with a remand. That's a good question, and it comes up in almost every case. Any other questions?
I have a question. So when you said that when we file the confidential records, the service requirement is a little bit different. So how is it different, and what is acceptable?
Yeah, so if you take a glance at the rules for this, unfortunately, it kind of reverts to paper service. But what I've seen parties do, though, is that it is just agree amongst themselves if they will consent to electronic service of the confidential brief. Typically, parties will do that because it's easier, frankly, on everyone, particularly during the pandemic. So that's something to consider as well. But yes, you cannot do it just through ECF. So make sure you look at the default rules and then consider mutual consent to electronic service via email.
So as long as the parties confer and basically consent to the electronic service, then that is acceptable.
I've seen parties do that, yeah. So, and I have not seen that be a problem so far, because again, it's just making sure that the other side has the document. So that usually only comes up as a problem if the other side doesn't have the document when they need it.
Thank you. Well, I think you must have covered everything that everyone wanted to know. Well, if there's no more questions, thank you so much, Angela, and thank you for everyone. This is going to, and I'm going to let everyone know once I get the confirmation from the Virginia State Bar on the CLE approval, and I'll let everyone know the process should they need it. Otherwise, thank you, and look for this on YouTube.
Thank you, Ashley.
Thank you. Have a great one. Bye-bye.